Here we will look at how legislation establishes decision-making powers. But first, a quick snapshot of statewide facts on local government in Western Australia. Western Australia has a great variety of local governments. For example, the Shire of East Pilbara is the largest local government area in the world at 372,000 square kilometres. The Shire of Peppermint Grove is among the smallest at 1.5 square kilometres. And the 2016 census informed us that the Shire of Serpentine-Jarradale was the fastest growing local government population in Australia, increasing from 18,000 in 2011 to 27,000 residents in 2016. There are 3 spheres of government in Australia. There's 1 federal government, 8 state and territory governments, and 537 separate and distinct local governments throughout Australia. Because local government makes decisions about so many things that affect our everyday lives, it is often described as the sphere of government that is closest to the people, the grassroots form of government. Providing for a system of local government is a residual power of the states. For this reason, no mention of local government is made in the Australian Constitution, and all matters pertaining to local government are made through the legislative powers of state parliaments. The power to make legislation relating to local government is found in the West Australian Constitution. Section 52 of the WA Constitution Act of 1889 requires the state legislature to maintain a system of local government and provide it with relevant powers. It is therefore often said that local government is a creature of state legislation. The Local Government Act 1995 is the legislation created by State Parliament to provide for a system of local government in WA. Local governments are created as body corporates with perpetual succession and a common seal, and are to be run by elected councils. The Act is created under general competence powers. This means a local government can make whatever decisions it believes is required to provide for good government of the people of its district, as long as it does not conflict with existing legislation or common law. Local governments provide a diverse range of services, generally falling under the headings of people, property, and regulatory services. As a consequence of state legislation, in addition to the Local Government Act, amounting to approximately 80 acts and hundreds of associated regulations, local governments must perform certain functions and provide particular services, as shown here. But local governments can, under general competence powers, choose to provide services for its community. These services will vary from place to place and include things like sport and recreation centres, community events, environmental protection, and tourism initiatives, amongst many other things. Now we will look at the separate roles of a council, the mayor or president, the council itself, and the CEO. We will then see how it all comes together to provide good governance. The Act states that the role of the council is to govern the local government's affairs. It is responsible for the performance of the local government's functions. Furthermore, it is to oversee the allocation of the local government's finances and resources, as well as determining its policies. The council also has a responsibility to ensure there is an appropriate structure for administering the local government. Importantly, it is the council who is the employer of the local government chief executive officer. However, the council has no further role to play with regard to any other employees of the local government. The Local Government Act clearly prescribes the role of a councillor. This includes representing the interests of the community, providing leadership and guidance, facilitating communication, and making decisions. Notice here that councillors have no individual powers. The Local Government Act prescribes the role of the Mayor or President. This person leads the council as a team and provides leadership to the community. The responsibilities of the role include presiding at council meetings, providing leadership and guidance, carrying out civic and ceremonial duties on behalf of the local government, speaking on behalf of the local government, and liaising with the Chief Executive Officer. The Mayor or President has a significant leadership role under these provisions, but as is the case with councillors, they have no individual powers. Also note the final item on the slide. The Mayor-President liaises with the CEO. This encourages the person leading the council to communicate regularly with the CEO, who leads the administration. The functions of the local government CEO are separate but complementary to the functions of the council. As can be seen, these functions relate to the administrative purpose of local government. The CEO is a principal advisor to the council, implements council decisions, manages day-to-day operations, and is the employing authority of all local government employees. Note under E, the CEO liaises with the Mayor-President. This ensures the smooth flow of information between the leader of the administration and the leader of the council. The council is the employing authority of the CEO, therefore all elected members participate equally in the CEO performance management review process. So the representative decision-making body of council performs a separate role to the apolitical professional administration that provides impartial advice and guidance. This arrangement mirrors the Westminster system at the state and federal level of government. As we have seen, individual elected members do not have any powers. Council is the strategic decision maker that plans for the needs of the community, creates strategic community plans, and monitors its implementation, allocates financial resources, and ensures the structure of the organisation is capable of delivering that strategic direction. It performs the decision-making function at formally convened meetings of council, where all elected members participate equally in making legally binding decisions. The administration is led by the CEO and is made up of professional officers who, under the CEO's direction, put into effect the decisions of the council, provide services to the community, and manage the local government's assets. While the roles and functions are separate, it's important to note that every decision and action performed is done in the name of the local government, the town, the shire, or the city, as a body corporate. It is recognised that there are some similarities between a council and a board, which can be seen here. Being board-like in your behaviour can assist you to develop a trusting, respectful, and constructive relationship with fellow elected members. By developing your capacity to make sound, objective decisions, you are more likely to participate in decision-making that is in the best interests of the people of the district. And just like a board, elected members promote and champion the decisions made by the council. There are some important differences between councils and boards that are important to understand. For example, councils are democratically elected and do not have shareholders or members. Instead, they have electors, ratepayers, and residents. And as with the board, elected members must observe the law, principally the roles, responsibilities and functions just described in this presentation. Your past experiences and learnings will greatly assist you if elected to council, but you cannot apply formally learnt practices or behaviours if they conflict with the statutory requirements of the Local Government Act. NIFO, noses in, fingers out, is a well-known acronym to anyone experienced working within a board structure. Noses in, ask questions and be inquisitive. Fingers out, do not interfere in operational matters or the CEO's functions. This is a very useful principle for elected members to remember and abide by. The consequences to an elected member of not observing the most important aspect, don't interfere, is a potential breach of the rules of conduct, and you could face an inquiry by the Local Government Standards Panel. If you are elected to council, the first duty you will perform will be the signing of this declaration, required before you can commence in your role as an elected member. By signing this declaration, you have committed to represent all the people in the entire district and pledge your loyalty to the future of your local government. It also references the rules of conduct regulations. So let's quickly look at these rules. As the declaration states, you're required to observe the rules of conduct regulations. It's therefore important for you to appreciate and understand the requirements of the rules, which cover the following key areas: standards of general behaviour, use of information, securing unauthorised advantages or disadvantages, misuse of resources, a prohibition against involvement in administration, relations with local government employees, disclosing certain interests not financial, and restriction on receiving and disclosure of certain gifts. Alleged breaches of the rules are reported to the Local Government Standards Panel, which can rule that penalties for a breach may occur. We will now look at meetings of council, the rules associated with meetings, how decisions are made, and behaviours at council meetings. Councils consist of democratically elected representatives who represent the community, provide leadership and guidance, and facilitate communication between the community and the council. The important work of a council occurs at formal meetings where legal binding decisions are made. As we have seen before, the Mayor or President presides at council meetings. The ordinary meetings of council are convened on at least a monthly basis to discuss matters of significance to the community and to make legally binding decisions. Typically, most meetings will deal with policy and strategy, dealing with development applications, major projects, annual budgets and monthly financial management reports, the range, scope and delivery of services, and monitoring performance and compliance. The Local Government Act sets out some important requirements that must be followed at council meetings. For example, the Act states that you must attend meetings and you may be disqualified for failing to do so. There needs to be a quorum of at least 1/2 of the number of officers of council for a meeting to occur. You must vote, and the presiding member must use a casting vote at ordinary meetings, and you must provide public question time of at least 15 minutes at all ordinary meetings. In addition to the Act, most local governments have adopted standing orders or meeting procedures local laws to guide the conduct of each meeting. This local law ensures all councillors present at a meeting participate equally and have a right to be heard. This ensures the fulfilment of the council's right to participate in the decision-making process. It is respectful to understand and abide by the rules set down under your council's meeting procedures, and penalties may apply for a contravention of standing orders. It is therefore essential that you make yourself familiar with your council's standing orders, as they may vary from council to council. A number of things contribute to councillors successfully participating in meetings. First, you will need to be well prepared by giving yourself enough time to read council minutes, agendas, and attached reports. You'll need to be across the annual budget and monthly financial management reports. You will join in the debate and you'll be an objective decision maker. Prepare to influence others and to be influenced by others. I'll now hand over to Cassie as we have an online poll for you to participate in.
Thanks, James. So we'd like to get you involved today by doing a quick poll. Please select whether you think the following statement is true or false. At a council meeting, I can exercise my freedom of speech and make any comment that I wish. I'll give you a few moments to select one, and don't worry, no one will be able to see who selects what answer. Okay, so as we can see, we've had 32% answer true and 68% answer false. The correct answer is actually false, and in the next slide describing qualified privilege, James will explain why. Thanks, James. Over to you.
Thanks, Cassie, and well done if you answered false. The reason the correct answer is false is that there are some limitations on what you can say. State and federal parliamentarians are protected by parliamentary or absolute privilege. Therefore, great care must be taken when councillors make statements at a council meeting or in relation to the affairs of the local government. A council member can only rely on the defence of qualified privilege whilst discharging his or her duties. As a general guide, council should make every effort to ensure that statements are factual, accurate, made in good faith, and not made maliciously, so that they cannot be impugned to give rise to a detriment, as this may leave you open to an action such as defamation or a breach of the rules of conduct regulations. As a councillor, you may be required to make declarations of interest in matters that are being considered at council meetings, and you may not be able to participate in that part of the meeting. So let's look at declarations of interest in detail. There are three main categories of interest that are likely to impact on you: direct, indirect financial interests, proximity interests, and impartiality interests. Let's look at each one individually. A person has a direct financial interest if a matter to be dealt with by the local government will result in a financial gain, loss, benefit, or detriment for that person. Note here that a financial interest includes a loss and a detriment, not just a gain or a benefit. A subset of financial interest is an indirect financial interest. And an indirect financial interest can be established by showing that you or a person with whom you are closely associated has a financial relationship with a person or organisation requiring a local government decision. Closely associated persons are defined in section 5.62 of the Local Government Act. There is no requirement in this case to establish the potential for a financial loss or gain. A person has a proximity interest in a matter if the matter concerns a proposed change to a planning scheme affecting land that adjoins the person's land, or a proposed change to the zoning or use of land that adjoins the person's land, or a proposed development as defined in section 563(5) of the Local Government Act of land that adjoins the person's land. An impartiality interest arises if it could reasonably be perceived to adversely affect the impartiality of the person having the interest and includes an interest arising from kinship, friendship, or membership of an association. There are some differences between financial, proximity, and impartiality interests. If you declare a financial, indirect financial, or proximity interest, you will not be able to participate in the decision-making process of council in any way. If you declare an impartiality interest, you will be able to participate in debate of a matter and vote at a council meeting. Due to the importance of your office as a councillor and the commitment you have made to the community, it is often stated that an elected member cannot wear two hats where the business of the local government is concerned. You are an elected member at all times during your term of office. The theme of this expectation runs through the Local Government Act, most notably in the requirement to declare conflicts of interest and not participate in decision-making when this occurs. Let's now look at the impacts of being a councillor on your home life. Elected members are typically well-organised people who can commit to local government activities. These activities include attending council and committee meetings, briefing sessions, reading and preparing for meetings, attending community duties, and attending to civic duties. As a consequence of your role as a councillor, you may experience fewer evenings at home, less time for personal recreation and hobbies, regular interruptions, for example, phone calls and emails, not being able to attend family occasions, your mind being focused elsewhere, and sometimes dealing with negative community sentiment or backlash. However, you can meet these challenges through commitment and effort, with the resulting benefits such as that you get to contribute to the development of the local government, you have the privilege of representing the interests of the community on council, you make important decisions that will have a major and lasting impact in your community, and you'll feel a sense of achievement and gain a feeling of self-worth. Let's also take a look at the growing influence of social media as a means of communication. Many current elected members maintain a social media presence and do so appropriately and effectively. They do this by refraining from making negative or denigrating personal comments about any aspect of their role on council. Keep in mind our earlier advice that you are always a councillor for the term of your office, and that you cannot wear two hats where the business of local government is concerned. The potential to breach the rules of conduct or even face a defamation action may apply to your social media use. If you choose to utilise social media, do so by maintaining a respectful, positive, and informative profile. We'll now look at some frequently asked questions. Do elected members get paid? Yes, the WA Salaries and Allowances Tribunal remunerates elected members based on a band that is allocated to your particular local government. You will either be remunerated by being paid an annual allowance, as shown here, or on a per meeting basis. The choice between these two options and the amount to be paid within the band is a decision for each council to make. And here is the amount that may be paid if council chooses the per meeting option. Mayors and presidents and deputy mayors and presidents receive additional remuneration in recognition of the leadership, civic and ceremonial roles they play. You will also be reimbursed for particular expenses associated with your role as an elected member. However, you cannot be paid any other amount unless the Local Government Act and the Salaries and Allowances Tribunal determination allows it. Must I live in a ward to run for election to that ward? The answer here is no, you do not have to live in the same ward. You must be an elector of the district to stand for council, regardless of whether it is a ward election or a district election. Every elected member has an obligation under the Act to make decisions that are in the best interests of the people within the entire district. Question 3, must I be an Australian citizen to nominate for council? What if I'm a dual citizen? It is not a specific requirement of the Local Government Act that you must be an Australian citizen, neither is being a dual citizen mentioned. First and foremost, you must be over 18 years of age and qualify as an elector of the district in which you're being elected. This will be through the WAEC electoral roll, commonly known as the residence roll, or through a claim to be enrolled on the local government's owner-occupier roll by making an application to the local government chief executive officer. Some people may be disqualified from nominating due to insolvency, criminal convictions, being a current member of parliament, or being a member of another council. And question 4, is it true that elected members cannot contact staff directly, for example, to ask them to deal with a particular problem? Elected members are required to follow established communication protocols. Elected members' inquiries should be directed to the CEO in the first instance, and the CEO may then permit directors and senior managers to receive inquiries. Following this communication protocol will ensure you are not seen to inadvertently direct staff, as this is exclusively the role of the CEO, as we have seen previously. Elected members have a wide range of resources and training at their disposal, so let's look at some of them now. Recent amendments to the Local Government Act now requires all candidates to complete a candidate induction session. This is found on the Department of Local Government website and takes approximately 45 minutes to complete. There is no assessment, just information. It is part of the nomination requirements that you complete this. Further amendments to the Local Government Act will require persons elected on the 19th of October to undertake what is called universal training. The Council Member Essentials program includes understanding local government, conflicts of interest, serving on council, understanding financial reports, and meeting procedures. You must complete the 5 core training units within the first 12 months of being elected. We have now reached the end of the presentation and will open the floor to questions. Please type in any questions that you have using the questions function shown earlier. Due to the high number of attendees, we may not be able to respond to all questions tonight. However, we will post a full written response to all submitted questions on the WALGA website within 5 business days. All registrants will be notified when this occurs. Please be patient while we consider the best response to your questions.
Thanks, James. That's been a fantastic presentation. Our first question tonight is, if I don't live in the electorate but own property in the electorate, can I nominate? The answer is yes, you can, but only in specific circumstances. If you own or occupy property in your own right, then you may claim electoral eligibility on the owner's and occupier's roll. And if your claim is accepted, then you will be eligible to nominate for election. If, however, your right to vote in the local government election is because you are a nominee of a body corporate for a rateable property owned or occupied by that body corporate, you will not be eligible to nominate for election. I'd recommend you contact your CEO and check your status on the electoral roll before the rolls close to ensure that you are eligible to nominate. Over to you, Tony.
Thanks, Lynn. Second question, what happens if I don't finish my training in 12 months? There is no formal sanction proposed for failing to complete the training within 12 months from your declaration of office, the 5 courses that form the elected member essentials training. Local governments will, however, have to include in their annual reports details of elected member compliance with the universal training requirements. The Minister for Local Government has also indicated that in this initial phase, compliance with universal training will be monitored before the state government considers whether or not sanctions may be necessary to improve compliance rates going forward. Over to you, Lynn.
Thanks, Tony. Next question is about who pays for the mandatory training and do I get paid for my time in attending the training? WALGA has been strongly advocating for state government to fund universal training for the whole sector. However, state government has not yet agreed to provide that funding. So the training will need to be funded from each local government's budget allocations. Under the current Local Government Act arrangements, elected members are not able to claim reimbursement for their time committed to the role. The Act only provides for elected members to be reimbursed for travel and childcare costs, and you need to provide receipts or evidence to support those claims. It should also be understood, though, that elected member meeting fees, whether paid per meeting or on an annual basis, have been calculated by the Salaries and Allowances Tribunal to include consideration of the broad scope of elected member activity outside of formal council and committee meetings. In this way, you are perhaps already remunerated for your time. Thanks, Tony.
Okay, the next question. I have a full-time job. On average, how much time will I need to devote a week to being an elected member? And is my employer required to give me time off? The answer to this is the level of elected member time commitment varies substantially between local governments and individual elected members. Many elected members say they allocate up to 30 hours a week. However, time commitments may be best understood by looking at the following criteria. 1, how frequently council and committee meetings are scheduled and how long these meetings usually last. Are there also agenda briefing sessions before each council meeting and regular concept or strategic forums for council members and staff? How detailed are the agenda? How many pages do they contain? That determines how much pre-reading is required. Or you may also wish to put yourself forward to represent the local government on other community groups, boards and committees. These are optional but can be an important contribution for connecting with and advocating on behalf of your community. In the end, you can expect that being a council member will have a big impact on your time and personal commitments. Make sure you're well informed about the extent of this impact before you nominate, as making sufficient time is important to you being a successful community representative.
Thanks, Tony. The questions are certainly coming in thick and fast now. Next question is, if I'm a real estate agent, is there any benefit to me becoming an elected member? First and foremost, the purpose of nominating for election to council is to serve your community. If you are successfully elected, you'll be required to make a declaration of office in which you will declare that I take this office upon myself and will duly, faithfully, honestly and with integrity fulfil the duties of the office for the people of the district according to the best of my judgment and ability, and I will observe the local government rules of conduct regulations. The role of an elected member cannot be used in any way for personal benefit. Misuse of the office of elected member may constitute misconduct under the Corruption, Crime and Misconduct Act. In any case, a real estate agent or in fact a property developer is not prohibited from being nominated and elected for council. However, you'll need to consider the implications of your work, as this may have, your role as an elected member will definitely have additional complexities in your requirements for disclosure of interest. So make sure that you've considered this carefully in making a decision to nominate.
Thanks, Lynn. The next question, thinking about qualified privilege, what if I make a statement in a council meeting that I subsequently find out is wrong? The answer to this is we're all human and are therefore prone to making mistakes. The key to managing the risk of making such mistakes is to ensure that you are well prepared before you attend any meeting. Make sure you have read and understood the information provided in the meeting agenda, and if required, that you have sought more information or checked your facts and assumptions with the CEO before the meeting. If, however, you do make a statement that is wrong, correct the record by seeking permission from the President or Mayor to make a statement at the next council meeting. Or if the statement was made at an informal council meeting or community event, consult with your CEO regarding the best method of perhaps offering an apology and correcting the information. In any case, you are responsible for ensuring that your behaviour and your statements are not defamatory, libellous, discriminatory, offensive, or constitute bullying or harassment. An elected member who behaves in any way that contravenes those legal obligations can be held personally liable with no protection under the Local Government Act. Over to you, Lynn.
Thanks, Tony. Next question is, how do I make sure my social media publications comply with the requirements for the authorised by name, address and printer's address to be published also? The WA Electoral Commission has advised that you should have those details on your social media landing page, which avoids the need for you to ensure that that content is published on every single thing you post. We'd recommend that you establish a separate campaign social media profile so that you are able to more effectively manage that profile away from your personal profile. The WA Electoral Commissioner website also has some specific guidance on using social media in campaigns, and I'd strongly recommend that you engage and read that information before starting to use social media for your electoral purposes. Thanks, Tony.
Next question, is there any recommended reading for new councillors, as some people participating tonight will get elected? There are lots of resources available for you. This webinar will be posted on the Welga Training website next week, and that's available. The Department of Local Government, Sport and Cultural Industries have lots of guidelines on their website. You could have a look at the council minutes of the council that you're looking to be a candidate for, and you could possibly attend a meeting. But once you are elected, the first thing that will happen is that the CEO of that local government will organise a formal induction for new candidates, and that will go through all of the things that are happening in that local government. In addition, the training that has been mentioned in this webinar, the 5 subjects required to be undertaken in the first year are core subjects that will help you within your role. Thank you.
Thanks, Tony. Next question I have is, if elected and I move out of the electorate, will I need to resign as a councillor? The answer is most often yes. For you to be qualified as a councillor, you must be an elector of the district. If your right to be an elector of the district is that you are a resident within the district and you move your residential address to outside the district, then, unfortunately, you would be faced with having to either resign or be disqualified from council. Thanks, Tony.
Thanks a lot, Lynn. The next question we have is, can you run for election for two separate councils at the same time? Well, technically you can, but however you can't, if you're elected to both councils, you can't stand for both councils, so you'd have to resign from one, and you would force that local government into having an extraordinary election. So it's not a good idea. You need to probably concentrate on the one local government and aim to get elected there. Over to you, Lynn.
Thanks, Tony. Next question is a really curly one. Can a councillor hold a committee position, for example, secretary, in a community group like a resident and electors association? This really can place a council member in a difficult position. The Residents and Ratepayers Association, or Residents and Electors Association, is usually there to advocate on behalf of the community to council. If you are elected to council, then your role is to represent the local government when interfacing with your community. And whilst your obligations are to listen and hear what your community has to say, you would be conflicted in your role if you remained a committee member on the Resident and Ratepayers Association. So clearly, if you are currently holding that position and were successfully elected, you'd need to examine and consider the impact of that role on your obligations as an elected member. Thanks, Tony.
Thank you, Lynn. The next question is an elected member permitted to abstain from voting? The answer is no. You're required to vote on all matters. The only time you won't vote on a matter is if you've declared a indirect financial or proximity interest where you can't be involved. If you don't have an interest, then you are required under your role to participate and vote on all matters. Thank you.
Thanks, Tony. Next question is, when it comes to nominating, on the electoral roll, my name has not been updated since I got married. Do I use the name on the electoral roll or my new name? As the fundamental qualification for nominating for election is your right to vote, therefore the name that you have recorded on the electoral roll must be the name under which you nominate. Thanks, Tony.
Okay, thank you, Lynn. We're on to the next one. As a councillor and a ratepayer, what is the provision in the Act that enables councillors to vote on the setting of rates based on their financial interest being presented here as excluding all councillors with a financial interest to vote? There's an exemption in the Local Government Act and all elected members are able to vote on the rate setting. Thanks, Lynn.
Thanks, Tony. What happens at a swearing-in ceremony? The swearing-in ceremony is the ceremonial occasion that is facilitated by your local government at which newly elected councillors sign their declaration of office. And it differs from one local government to the next. Some local governments hold the swearing-in ceremony immediately before a special council meeting at which the local government establishes its new committee arrangements and appointments to external boards and committees, as well as the election of mayor or president and deputy mayor or president. At this ceremony, it can be presided over either by the CEO of your local government or a notable dignitary who holds a specified position under the Oaths and Affirmations Act. In either way, it will be a very special ceremony for a newly elected council member, as this is the point that they take up the official office and the roles and responsibilities of a council member in serving their community.
Thank you, Lynn. We've got a series of questions around the universal training, and I'll try and compact them and answer them as one. So firstly, there are a number of ways that the training can be carried out. It can be carried out online, electronically. There are 3 service providers who can provide the training for local governments. It can be carried out in person at the location of the training establishment, or most training establishments will also come to the local government, and it can be held in the regions at a local government. Sometimes local governments combine together and get the training done at a regional location together. So lots of opportunity to get the training in a number of different formats. Thanks, Lynn.
Okay. Next question is, I understand a councillor has a routine and that they are committed to attending meetings and unfortunately, in my circumstances, I have other commitments which mean that I may not be able to attend a council meeting 3 to 4 times a year. In that circumstance, the Local Government Act provides for a council member to apply for a leave of absence from council. There are, however, limitations around the number of meetings that an elected member can be absent from without an approved leave of absence. Once elected, it's important for you to maintain awareness of whether or not you have missed 3 successive meetings in a row without an approved leave of absence, as this is the threshold for disqualification from council. Once you are elected, however, work closely with your CEO when you are aware that you can't attend a meeting and need to submit an apology or apply for a leave of absence. Your CEO will assist you through the process.
Thank you, Lynn. Further question, are most council meetings in the evening, and what commitments are required during normal business hours? You really need to have a look at your own local government. They vary as to whether they're evening meetings or daytime meetings. So I'd be contacting your local council office, speak to the CEO to find out what's the meeting schedule for that local government.
Thanks, Tony. Just looking through the questions here to see if we've not answered one.
You've probably got time for one more question.
Okay.
I've got a quick one on how do you know which band a local government is in. On the Salaries and Allowances Tribunal website for local governments, you'll see reports, and they list the last report in 2019 will list the bands of all the local governments. There are 4 bands. Band 1 are the largest local governments, and Band 4 are the smaller local governments. So if you go to the Salaries and Allowances Tribunal website, you'll be able to see that, or you could ring your local government and the staff there would be able to tell you.
Thanks, Tony. We'll hand back to James briefly. Thanks, James.
Thanks, Lynn and Tony. Ladies and gentlemen, we are almost at the end of our session, so we'll have to end public question time there. Thank you so much for your questions. As previously stated, we will be posting a full recording of this webinar on the WALG website within a week's time, along with all the written responses to the questions posed during and after this event. If you need any further advice or assistance on this topic, please don't hesitate to contact the WALGA governance team. Here are our contact details and the names of the members of the team, 3 of whom you've met tonight, of course. We wish you all the best of luck in the coming elections and look forward to continuing to work with all local governments across the state. I'll now hand over to Lynn to provide some information on the Hands Up research project.
Thanks, James. So, why do people put their hands up to serve as council members in their communities? The truth is, we don't know. That's why the Minister for Local Government, the Honourable David Templeman, has initiated a collaborative research project to be led by WALGA in partnership with the Department of Local Government, Sport and Cultural Industries and the University of Western Australia. The Hands Up project aims to establish benchmark data about elected members in local government in Western Australia that will allow us to monitor trends. It will determine the motivations for people putting their hands up for election or re-election and identify issues and challenges they face, and identify success factors that support their contributions to their respective councils and maximise the quality of decision making. If you are thinking about nominating for election or re-election, we'd love you to participate in this project. It will run over 4 years and will involve easy to complete online surveys and periodic interviews, asking you about your motivations for nominating, your experiences as a candidate, and if elected, your experiences as a councillor. Registration to participate is easy. When you complete the online candidate induction training, just select the Yes, I'd like to participate box and provide your contact email address. If you'd like any additional information about the project, please email or phone the project team. Thanks for listening, and I hope you volunteer to participate. I'll now hand over to Cassie to close the webinar.
Thanks, Lynn. Thank you everyone for coming, and to James for the informative presentation, and to Tony and Lynn for providing responses. As mentioned earlier, we will email registered participants with a full list of questions and answers provided, including any questions they weren't able to answer during the webinar. As previously mentioned, you will be able to access this webinar and our previous webinars on the WALGA website under Training and Webinars. Please allow around about a 5-day turnaround. And if you have any further questions on this topic or any other governance matter, please phone WALGA or email us at governance@walga.asn.au. Thank you again, and from all of us at WALGA, we wish you a very great